To introduce our group member, Ridwan Harib bin Abdul Razak, Muhammad Amir Arsyad bin Muhammad Nasran, Khairun Farsa binti Roslan, and Siti Ashafatia binti Rahman. Today I would like to present about discharge of contract. Determination of contractual obligation or the dissolution of contract is referred to as contract discharge. The word discharge refers to the act of withdrawing or being discharged for a civil duty. A discharge of the contract happens until a legally binding contract fails to be legally binding. And next, as we can see, there is a few approaches that can be used to complete the contract. By the example, consent or arrangement, impossibility or irritation, or task split. And then, I will explain about discharge by performance. When all sides has properly fulfilled their statutory duty, they are also said to be discharged by result. If one party fails to complete a deal, it will be considered a breach of contract, and the other party will be entitled to damage because the contract has been frustrated. The other side will be relieved because their commitment, if the non-performance amount to a reparatory violation, is a breach of condition. When the price of contract is due upon expire, it's normally appropriate to conclude the contract in order to discharge it. According to section 56(1), case of Xing Qiuhua versus Huang Teofil, this group have failed to complete within the defined time frame, and the innocent party has the option to rescinding the deal, or the innocent party can continue to handle it as although it already exists. And then I will explain about discharge by agreement. All sides can voluntarily discharge their duties as long as they insist to do so. What happen is, for example, if one person have tank of her heart and want to do reforest their obligation, the arrangement can be reforced at the stage because as the agreement to discharge duty has no legal basis, despite the fact that it's a perfectly legal made agreement. As a result, it's a proposal that a party enter into a second contract that hold all parties to their promise to meet the contract obligation. And then I will tell a little bit about section 63. If the party to deal agree to amend with a new contract or rescind it or maybe change it, the original contract doesn't need to be have made. And then section 64. Any commitment may dispense with or remit the fulfillment of the promise given, but in word or in party may provide the time for such fulfillment or may accept any gratification in place of it and that if necessary.
Contract discharge by agreement. First one is novation. Novation, it is where a new contract is made to substitute the original one. All the parties must agree. As a result of this, the obligation of the parties under the original contract are discharged. This can be seen in the illustration clause A to section 63. A owes money to B under a contract. It is agreed between A, B, and C that B shall henceforth accept C as a debtor instead of A. The old debt of A to B is at an end, and a new debt from C to B has been contracted. Next one is alteration. Alteration, when all the parties agree to alter one or more condition of the contract, hence the obligation to perform the original condition is discharged by agreement. Next is rescission. Rescission is when both parties to a contract agree to terminate the contract they made. So if both A and B agree to put an end to the contract that they have already made before they perform it, the contract is discharged by agreement. So A and B is no longer under obligation to perform it. Next is remission. Remission clause B to section 64, A owes B 5,000. A pay to B and B accepts. In satisfaction of the whole debt, 2,000 paid at the time and place at which the 5,000 were payable. The obligation to pay the whole debt is discharged. Illustrations of clause C. Illustrations clause C to section 64. A owes B 5,000, C pays to B 1,000, and B accepts them. In satisfaction of his claim on A, the payment is a discharge of the whole claim against A. When a performance will be considered unrealistic due to an unexpected occurrence, annoyance, or impracticability exists. If an individual is unable to complete a contract due to an incident that occurs after the contract has been executed, this is known as impossibility. Contract of employment was discharged by frustration on the outbreak of war when Japan invaded Malaya. In the case due to the invasion of Malaya by the Japanese force, the European staff of the defending company was evacuated from Trono, Tanjung Tualang and other places. As a result of this plaintiff, one of the staff in the company brought an action against the defendant company for breach of contract of service. The court held that the invasion of Malaya by the Japanese frustrated the performance of the contract. Hence, there was no breach of contract by the defendant. The claim by the plaintiff was therefore dismissed. There is a breach of contract rather than a warranty breach. In addition to seeking damage, the innocent party will be entitled to repudiate the deal, putting the contract to an end. A breach of warranty does not discharge a bond. It was held that the refusal to issue an architect certificate as agreed under a contract amounts to a breach of contract because it prevents the contractor from proceeding with the construction of the building. Since it is important in the contract, the party not in default has a choice either repudiating the contract or treating it as subsisting.
Now I'm going to talk about remedies for breach of contract. Is the content in rescission of contract. If a party refuses a contract promise, the party who wasn't in dispute has the right to resign or cancel the contract. Under Section 40, when a party to a contract forbids or detacts himself from implementing his promise in its entirety, the promise may put an end to the contract unless he has shown his acquiescence in its continuity by words or conduct. Case Muralida Chatterjee versus International Film. In this case, the help said that the contract had been rescinded by the respondent and hence he was entitled to receive the advance money under Section 24. Damage. Damage are awarded to a claimant as a compensation for the cost, harm, or injury sustained as a result of a breach of contract. Section 76 said an individual who duly rescind a contract is entitled to liability for any loss suffered as a result of the contract's non-fulfillment. Case Yong Mok Hin versus United Malay Sugar Industry. Type of damage. Damage resulting from natural cause or ordinary damage. There are damage for the injury or harm incurred by infringement that actually occurred as a result of the regular course of event. Special compensation for any special loss incurred. It is institution for any harm or harm incurred by a violation of contract that the party in breach is aware of. Liquidated damage. The amount of damage to be incurred in the case of a violation is often defined in the settlement by the parties. As a consequence, the specific amount is the highest amount of liability that can be received in the case of a violation. Categories of damage: substantial damage, pecuniary, monetary settlement, intended to place the complainant in the role he would have been if the deal had been fulfilled. Nominal damage, when a complainant has proved a violation of a statutory right but has sustained no real injury, he or she is entitled to a nominal token reward. Exemplary damage consists of a cash reward well in excess of the plaintiff's real pecuniary or monetary injury. Specific performance. A court ordering to the party that failed to carry out the contract in compliance with its term is known as precise performance. It obligates the negotiation party who is in violation of the contract to satisfy his contractual obligation or to execute the contract as negotiation. Section 21 of SRA. The authority to order particular performance is discretionary.
Okay, situations where specific performance may be granted. For the first, when the act agreed to be done is in the performance, wholly or partly, of a trust. Second, when there exists no standard for ascertaining the actual damage caused by the non-performance if the act agreed to be done. Third, when the act to be performed is such that pecuniary compensation for its non-performance would not afford adequate relief. Fourth, when it is probable that pecuniary compensation cannot be got for the non-performance of the act agreed to be done. 5. Useless, and until the contrary is proved, the court shall presume that the breach of a contract to transfer immovable property cannot be adequately relieved by compensation in money. So, as my opinion is the most common the most common reason courts grant specific performance is that the subject of the contract is unique when it's not merely a matter of money or where the true amounts of damage is unclear. When the contract is for the sale of a unique property, for instance, mere money damage may not remedy the purchase situation. So the section 22 cross 2 of SRA give the court the discretion not to enforce specifically a contract in the following situation: where the circumstance under which the contract is made are such as to give the plaintiff an unfair advantage over defendant. So there may be no fraud or misrepresentation on the plaintiff's claim, where the performance of a contract will involve some hardship on the defendant which he did not foresee, as it not performance will involve no such hardship on the plaintiff. Section 18 Clause 3 of SRA give power to court to award compensation in addition to specific performance. If specific performance is not sufficient to justify the justice of the case. Moving on to the next point, which is injunction. So injunction is a court's order to restrain the doing, continuance, or the reputation for some wrongful conduct which is against the contract. Classified as preventive relief, Section 50 of SPA. Preventive relief is granted at the discretion of the court by injunction, temporary or perpetual, when the contract contains negative agreement of the agreement can be prevented by injunction. Means that specific performance that are possible are also cannot be carried out when the person had breached the contract. In this option, injunction can be said as a remedy that is equitable, that the court requires the party to do something or the other way to stop him or her from doing something. So there's a types of junction. A temporary injunction, section 51 cross 1. Temporary injunction are those that are to last for a set period of time or before further order of the judge. They can be granted at any time during the course of a suit and are governed by civil procedures rules. So B, perpetual injunction, section 52 cross 2. A perpetual injunction can only granted by the decree made hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the. Moving on to the next final slide, which is quantum merit. Quantum merit is a legal action based on equitable compensation. It is an alternate remedy to an action on a contract which can be brought for partial performance. A claim in quantum merit can at best be described as a residual equity. Procedurally, quantum merit is the name of legal action brought to recover compensation for work done and labor performed, where no price has been agreed. The term literally means as much as it deserves, and often can be seen as the legal form of equitable compensation or restitution. In a claim of quantum merit, the plaintiff does not seek a precise sum of money, nor a sum representing the general damage incurred by the plaintiff as a consequence of some unjust act on the part of the defendant, but a sum which will provide the plaintiff the value of the value of what the plaintiff has done for the defendant, usually calculated in terms of the market price or value of the service. Section The claims arise in two kind of cases: A, where one party abandons or refuses to perform the contract. Case Planch versus Colburn. It was held that C. All right. So the case Planch versus Colburn is it was held that C has repudiated the contract and P was entitled to treat it as the discharge and recover a quantum merit for the work he had already done. So for the B, where work has been performed and accepted under a void contract case, Craven Ellis versus Canon Limited. It was held that P could recover on quantum merit since there being no any valid contract. If the existing contract, which does not have the details such as the price is not fixed, the seller is entitled to reasonable prices as a quantum merit. So that's all from us. Thank you.